Aloha, this is Professor Porter. We're talking about the Federal Rules of Evidence in particular, kind of a unique video, a unique series of videos talking about renaming rules of evidence. And it's not renaming them because I have some type of spite that they didn't consult me or ask me when they were naming the rules. It's more that as much as the rules are adequately named to serve their purpose as rules, they don't necessarily assist someone new to the Federal Rules of Evidence. They don't necessarily assist the new learner. As a matter of fact, a lot of them have traps in them. If you go off the title of the rule, it necessarily traps you into an analysis that's maybe not what you want to be talking about, or maybe not how you want to be analyzing it. So I think of some renames, some relabels for these rules of evidence to help you and assist your learning. This is a second part, or at least an episode that has to do with hearsay and renaming some of the rules that have to do with hearsay. Okay, the first one has to do with the actual rule, Rule 801. Rule 801C is the definition of hearsay. I think it's one of those things that now has earned its own place when people think about quoting others and saying things about others. They think about the word hearsay. When you hear the word hearsay, you think about law school and lawyers, and they're the ones that own that term. For me, I think we dump it, and I think 801 is called something else. I like quoting or impermissible quoting. That's really what hearsay is, right? You have a witness on the stand and they're talking about and quoting someone else who's not here, or quoting themselves from an earlier time. You're quoting someone impermissibly who's not here for the jury to observe, who's not here for the opposing counsel to cross-examine. So really what Article 8 is about and what Rule 801 definitional hearsay is about, it's about quoting. It's about impermissible quoting. So just imagine a day in Porter's universe where we had objection, impermissible quoting would be something that happened in court. And then you'd actually be having a substantive conversation about this witness is quoting this out of court declarant impermissibly. And then you'd go into exceptions and the like. Okay, the next one applies equally to our exceptions to hearsay, and the first one is 8031, present sense impression. I think present sense impression is one of those expressions that confuses students, confuses those new to the rules of evidence. They just expand it to mean things that it does not mean. Present sense, it's like, well, I'm presently here. I'm saying it now. This is my impression that I have at this time, and oftentimes that's wrongly applied. So I suggest we dump it and instead think of talking without reflection. That's really what present sense impression is meaning. That's really what the rule makers intended by 8031, talking without reflection. The two examples that I use in class that I think most law professors use, thinking of an on-the-scene reporter. CNN sticks someone out there and they're in front of a scene and they're actually observing things and talking at that time. They're not making a report based on prior observations. They're looking around saying, that person's going that way. I just saw this happen over there. They're reporting right at the time without any opportunity for reflection. The same thing with someone who's on the phone for unrelated reasons, and they are looking out the window, and they're on the phone with a friend, and then they see something unexpected. They see someone, they're looking out into the park from their window from an apartment, and they see someone breaking into a car, and all of a sudden on the phone with their friend, they start describing that event. They're talking without reflection. Oh my God, he's going around to the driver's side. He's looking at the red Tercel. I think he's trying to get in. I think he's breaking into this car. I can't believe this is happening right now. What should I do? Talking without reflection. That's what's meant. It's got to be contemporaneous or immediately thereafter. So every time that you're faced with, a statement at a podium, a speech, a tweet, a post on any type of social media, there's always some type of reflection involved. There's some type of let me think about what I want to say. This is the rule. This is the exception that is for those times when we didn't think about what we want to say. We just said what we were observing. Talking without reflection is a much better way to understand 8031 and make sure that you don't apply it too broadly. It's not anything that happens in the present. 8032, one of my sort of my favorite mislabeled words. Excited utterance is a terrible name for this rule. I think it's just one of those things that's been grandfathered in from the common law, and all of a sudden one jurist in one opinion said the word utterance, instead of statement, instead of exclamation, and it's just carried on through sort of the tradition of common law, and it was codified as part of different state codes and California State Code of Evidence, and then made part of the Federal Rules of Evidence. It makes no sense. I think when people think about an utterance, they don't think about doing so while they're excited. That's kind of something that you would say under your jacket to someone. I uttered a few words during the ceremony. It just doesn't make sense, and it confuses people. Were we to dump it? Talking while excited. I love rules that the title of the rule and what you remember about the rule in a snapshot actually gets you there. 803.4 by contrast says statements made for purpose of medical diagnosis and treatment. That tells you what the rule is. It's a statement made for medical diagnosis or treatment. Excited utterance doesn't tell you much about this rule. Talking while excited. And it's that's really it, right? If I'm talking while I'm excited about the thing that made me excited, I'm pretty much there as it relates to the foundational requirements of 803.2 for the proponent. So if you think about talking while excited, or really on the hunt for exclamation points, talking while excited, exclamation point. I can't believe this fire happened. I can't believe this happened. I can't believe that possibly our competitor did this. I'm saying all those statements with an exclamation point. I'm saying them, it's an excited event. I'm talking while I'm excited, and of course my statements relate to the excited event. Some type of talking while excited edit would really help and get rid of utterance. Okay, 803.3, it now has a better name. The rule makers have done a better job, but it's popularly known to law students. It's popularly taught as the state of mind exception. I hate that, because when we teach it as the state of mind exception, all of a sudden it narrows down to what's going on in the declarant's mind. It's just a state of mind thing, and it's really not. The rule is far more broad than that. Even before you get to the present intent to do a future act, which is part of this rule 803.3, it has to do with my then existing physical state, my then existing emotional state, my then existing mental state. It's much more broad than my state of mind. So I really don't like when it's collapsed and narrowed to just state of mind. And then, of course, we have my present intent to do a future act, my plan, and what I'm going to do next. So we dump it. Then existing conditions. Conditions, what's going on with the person who's talking, then existing conditions. And the rule does a pretty good job of this. It's physical conditions, it's mental conditions, it's emotional conditions. I'm hungry, I'm jealous, I'm tired. They're all sort of then existing conditions. As long as it sort of starts with an I'm and describes what's going on with that person, anything after because I didn't sleep all weekend, the explanation is out, just the then existing state of condition of what's going on with the declarant. And I think you got to put in the rule, if you want to help out those new to the rules, including present intent to do future acts. I plan to go golfing this weekend. It qualifies under 803.3 because it's a present intent to do a future act. That's also in. It's the same as I'm hungry. I plan to go golfing this weekend. It's the same as I'm hungry. So titling the rule instead of narrowly with state of mind, where students will unfortunately collapse it just to that one thought. It's then existing conditions going on with a declarant, including my present intent to do a future act if I'm the declarant. Okay, recorded recollection. This is one of my pet peeves in all of evidence. This is just designed, I think. Recorded recollection is designed to confuse you. It's designed to be confused with refreshing recollection. Sounds a lot alike. They're both R's, RR and RR. Refreshing recollection, of course, is a process that I can take usually on direct examination. If I've sponsored a witness and I've prepped my witness to anytime they say the words "I don't remember" to anything, that I let them know there's a process that we can return to. If you say you don't remember and you've remembered somewhere else, if you said so in a statement, said so in a prior statement, said so in a deposition, then it's no problem. You say, I don't remember, we go into a process called refreshing recollection. And refreshing recollection, I have other videos on it. It's a litigation process that you have to know. It's a process that you absolutely have to prepare all your witnesses for, that we have this tool available to us. But if someone says the magic words, I don't remember, where were you on the night of May 23rd at 9:30? I don't remember. That's the beginning of the foundation. That's the trigger to the foundation for refreshing recollection, not yet recorded recollection under this hearsay exception. Under refreshing recollection, we would go into a process. I would say, would looking at your statement assist your memory? Yes, it would. I would be able to make sure that opposing counsel had that statement and knew the portion I was going to show to the witness, approach the witness, be able to present that to the witness, direct them to the exact part they had to read that shows where they were on that date and time. It could be highlighted, it could be blown up. Say, read this to yourself. Very key. Don't read it out loud. You read it out loud, it's hearsay, objection sustained. Read this to yourself. When they read it to themselves, then you tell them to flip it over when they're done. Did reading that assist your memory? Did reading that refresh your recollection? Yes, it did. You return to the question. Where were you on that date at that time? They answer the question. So that's all it is. That's a process, refreshing recollection. And it's not susceptible to hearsay because we're never having them read. We're assisting their memory with something that was once theirs, flipping it over, and now we've refreshed their memory, and now we're asking a contemporaneous conversation which doesn't violate the hearsay rules. So any objection to hearsay during that process is going to be objection hearsay overruled because they were not asking them to read out from their prior statement. Instead, we're showing them, flipping it over, asking if it helps, then returning to the question. Recorded recollection is even more narrow than that. It's why it's the wrong answer on a lot of multiple choice questions. Recorded recollection is for the rare instances when we show someone something during this process of refreshing recollection, and even during that process, we can't refresh their memory. It is the unrefreshable memory. And really, if you think about it, if it's something so complicated, they wrote it down in a report. Maybe it's the serial number for a TV, maybe it's a license plate, maybe it's a complex code that was part of what the drug dealers were talking. Whatever it is, it's something that even upon showing them, reading it, flipping it over, saying, do you remember what that is? I said, I'm sorry, I still cannot do the serial number to the TVs that were stolen in this case. It's understandable. It's a 28-letter number combination. At that time, what this hearsay exception lets you do with those foundational requirements, I don't remember first, attempting to refresh recollection. Did that assist your memory? No, it did not. It allows us to flip the page back over and read that into evidence, read the serial number for the TV. That's all recorded recollection is. When you're reading off that document that was the witness's prior statement, objection hearsay, Your Honor, while this may be hearsay, an exception applies. This is a recorded recollection under 8035. A lot of times when they ask questions about this, when they ask questions about recorded recollection, what they're really hoping is that you confuse the litigation process of refreshing recollection of your own witness on direct and the hearsay exception of recorded recollection when it has to do with unrefreshable memory, those rare instances when I'm showing the witness the answer, asking them to flip it over and return to the question, and they still can't do it. It's usually just for longer or complicated answers, often a wrong answer on multiple choice. Okay, this is one of my favorites too. Rule 803.18, learned treatise, right? It sounds good to say. It sounds like it's a good option to have in a multiple choice question, but it applies really narrowly. You're really talking about cross-examination of experts that are governed by Article 7. You've properly disclosed an expert's report. You have the opinions and bases for an expert. You've asked direct examination questions of an expert, and on cross-examination, you have a medical expert up there. You're able to go to a sort of a published known source in the field of that expert. You're able to go to Gray's Anatomy. You're able to go to the DSM-4. You're able to go to some treatise, some document, some periodical, some publication to say, can I ask you about this? Do you accept this as a truth in your field? That's what learned treatise is. And of course, all those things, Gray's Anatomy is hearsay. It's an out-of-court statement by the authors of Gray's Anatomy, offered for the truth of the matter asserted. We let it in as an exception. And I think learned treatise is confusing, and it doesn't cover everything that it stands for. We dump it. Publish stuff that this expert should know. That's it. If you have published stuff that this expert should know, then it's allowed into evidence, and you'd have some questions and maybe even some evidentiary discussion and debate about whether this is proper, this is within their field, this is something they should know. But once it's within their field and once it's something that this expert should know, like a medical expert and Gray's Anatomy, you'd be able to pull out individual statements and read them into the record for that doctor. And when you read them in, objection hearsay, Your Honor, while this may be hearsay, an exception applies. 803.18, learned treatise. But just think about it. It's published stuff that an expert should know. It's not anything that's going to come up in any other context. Can't use a learned treatise with a lay witness. And you can't all of a sudden put a learned treatise and all that it is into evidence. You're reading out applicable, relevant portions to an expert on cross-examination. Okay, we got a few of the unavailability exceptions. In 804B, of course, 804A establishes unavailability. You can't go to these exceptions unless the declarant is unavailable. Former testimony, it's a little bit confusing. Yeah, there's lots of testimony that's former. The grand jury is former. The depositions are former. If they testified in a preliminary hearing, that's former. So it is not as broad as the two words former testimony would have you say. Prior, full-on, suitable substitute for testimony. This has to be, I have a different video that describes this in terms of ICE. You really have to have some time, because this declarant is unavailable, some time where a full-on suitable substitute, they testified, the other side was there, or at least their predecessor in interest was there. They had the opportunity to cross, they had the same motive to cross, and that whole testimony, because all the same players were there, can be picked up from trial 1, declarant's not here, trial 2 can be plopped into place. So instead of just former testimony, which a lot of things qualify as former testimony, it's got to be this big suitable substitute, this full-on suitable substitute that can be plucked out of some prior proceeding and placed into this trial as if it happened live and in color. So former testimony is a little too narrow and something more. Visit my video having to do with the ICE analogy of what we can do with prior statements. Okay, 804B3, also an unavailability exception, also one where the declarant has to be unavailable for you to even turn as the proponent to this exception. Statements against interest, I just feel, is a lure to be the wrong answer. This is often put in as a wrong answer against statements offered by a party opponent, not hearsay under 801D. And statements against interest, it's just a generic statement that says statements against whose interest, statements, it's a little broad. So we dump it. Why else would they say that if it were true? That's what this rule should be named, because we're really talking about declarants that are no longer here, that are not here for some acceptable reason under 804A. They are unavailable for trial. And we're looking at their statement and we're saying, why else would they say that? They're saying something so honest and so true and so against their interest that we're going to allow it into evidence. But statements against interest get too broadly defined. They apply to parties, they apply to criminal defendants, and really what we're talking about is declarants that aren't here. Declarants that aren't here, unavailable declarants. Why would they have said that? And just remember, with this rule, it's often forgotten. There's no way to put it into a change of title, a relabeling. That in a criminal case, if someone is saying essentially, I did it, I'm not the criminal defendant, but I'm coming here as a witness, or I'm coming here as a declarant, and I say, I did it, and then I'm going to be unavailable for trial, we're going to require corroboration. But it's like, why else would someone say that? It's a statement that's so against their interest if it weren't true. So we're persuaded by the fact that they're not there and they wouldn't have said something so viciously against their own interest to be used at trial. Statements against interest, often a wrong answer in multiple choice.